arrows, axes high, shields strong. From distant lands we gather, hearts of fire all along. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big Nick calls we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey, oh, folks. Welcome. Good to have you here. Little late start because I was tired. Yesterday, I woke up 4:15 a.m., as I usually do. Went off to work, and then we had this work get-together after work. Playing, yeah, I don't like those. I'm not that type of person. I mean, I see these guys and gals 8 to 10 hours a day. I want to go home. But this was mandatory as a team building effort. And I told my boss, sir, do I have to? Yeah. So off we went and ate and talked, and I mean, it was nice and so. And then I got home, and then I streamed for an additional 4.5 hours yesterday, and I was done at 3:30 a.m. So a 23-hour day. Folks, I'm old. That's taxing on me. So I woke up this morning, did the obligatory things around the farm, and then I just told myself, nah, I'm going back to bed. Because I told my boss yesterday, I'm taking tomorrow off. Nah, not coming in. Yeah. Because, and it was very easy for him to give me the day off today, because today is Christ Ascension Day, which is a national holiday in Sweden. So yeah, it wasn't hard to give me the day off. So yeah, I'm having the day off. I'm spent relaxing, nap. I'm having multiple naps today. So now I'm close to human, at least close to human. And so yeah, I was supposed to start at 8 a.m. Eastern time. It is now 10:30 a.m. Eastern time. So it's not that bad. Oh, and folks, we are currently streaming on YouTube, X, Rumble, and for the first time in a good while, Kick. Let's see how it works out over at Kick today. Last time I was over at Kick, it's a number of months ago, and I had one viewer. Now, very, very nice one who was active in chat, but doing all the things, because over at Kick they haven't done anything about the bot problem. So I assume when I regularly streamed over there, I have to go in there and ban bots. So if you hear me in the middle of anything go, oh, for the love of, you know what, I'm probably banning a bot over at Kick. So, what are we going to talk about today? Oh, thank you. Thank you. Saying time doesn't matter. We're here. Thank you so much. Yeah. We are talking about the Alec Murdaugh appeal. It was up in the South Carolina Supreme Court. So we're going to talk about that. We're going to read from it. And because it's a very, very interesting Supreme Court decision, unanimous, and it's not. I had the impression yesterday it was all about Becky Boo being the type of person she is, and we're only like 6-7 minutes in, so I can't say the proper words about her. But they also brought in, all that financial stuff. That was bad as well. And that makes the retrial a whole new trial. But we're going to get there. We're going to get it. And then after we're done with that, we're going through the Kouri Richins sentencing. Now, I'm not going to go through all of it, just the worst of it, which is, of course, Kouri Richins in more or less a prayer circle, blaming everyone but herself. So we're going to. So first part is for you who like my when I analyze legal documents. Second part is for you who likes the snark attacks, because I have a feeling there's going to be a lot of that. Hi Mandy, hi, good to have you here. I'm Gumby, damn it. Thanks for being here. In Zim and Pop Princess and Joni and Denise and Neat Scholar over at Rumble. Good to have you here. And so yeah, good to have you all here. So folks, this is what we're going to do. This is what we. Hold on. Well, I remove that. Sorry, I have to make you a bit smaller so I can be seen. Let's do that as well. All right. The Alec Murdaugh Supreme Court decision. Hold on to your breeches. A lot of, by the way, before I forget, a lot of people say, well that it does. It's so obvious. So why bother having a new trial? Because it wasn't a fair trial, folks. The people you believe are the worst of the monsters are the people who have to have a fair trial. Because if they don't, none of us gets a fair trial. These are the cases that are the most important, to see that the rules are followed, that laws are followed, that statutes are followed. Yes, it's going to cost a shit ton of money. Yeah, it's going to take time. And yeah, a lot of people believe it's unnecessary. But it is necessary. Because if he doesn't get a fair trial, none of us are guaranteed one. None of you. None of me. None of us. That's why it's important. All right. Now let's start. The state respondent versus Richard Alexander Murdaugh appellant. Appellate case. Appeal from Colleton County, Clifton Newman, blah, blah, blah. Opinion heard February 11th. Reversed and remanded. So, that spoiler already. And the people involved are Richard A. Harpootlian, Philip Donald Barber, and Andrew R. Hand, all of Richard A. Harpootlian, PA. James Mixon Griffith and Margaret Nicole Fox, both of Griffin Humphreys, all of Columbia for appellant. And for the state, at AG, Alan Wilson, a lot of people for respondent. Oh. Per curiam. For 6 weeks in early 2023, the eyes of the nation focused on Colleton County, where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife, Maggie, and son, Paul. Both the state and Murdaugh's defense skillfully presented their cases to the jury. Sure. As the trial court deftly presided over this complicated and high-profile matter. However, their efforts were in vain because Colleton County Clerk of Court Rebecca Hill placed her fingers on the scale of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. Our justice system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury untainted by external forces bent on influencing the jury towards a biased verdict. Although we are aware of the time, money, and effort expended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for a new trial due to Hill's improper external influences on the jury and remand for a new trial. Because we order a new trial on this basis, it is not necessary that we review every evidentiary issue Murdaugh raises on appeal from his conviction. However, we address the admissibility of Murdaugh's financial crimes to offer guidance of this thorny issue to the trial court on remand. Factual and procedural background. On March 2nd, 2023, Murdaugh was convicted of the murders of his wife, Margaret Murdaugh, and his son, Paul Murdaugh, as well as 2 counts of possession of a weapon during the commission of a violent crime. The trial court, Judge Newman, sentenced him to life in prison. While his direct appeal of these convictions was pending at the Court of Appeals, Murdaugh filed a motion to hold the appeal in abeyance to allow him to file a motion for a new trial. The Court of Appeals granted this motion. On October 22nd, 2023, Murdaugh moved for a new trial, asserting Hill tampered with the jury by 1, advising to not believe Murdaugh's testimony and other defense evidence, 2, pressuring it to reach a quick guilty verdict, and 3, misrepresenting information to the trial court in an attempt to have the trial court remove a juror she believed to favor the defense. This is quite nasty against Becky Hill, and also this is quite nasty against prior proceedings. Chief Justice Beatty appointed former Chief Justice Toll, post-trial court, to preside over this motion, as the trial court judge had recused himself. The post-trial court conducted the hearing of this motion January 26th and 29th, 2024. Jesus, is that long ago? During the hearing, the post-trial court asked each juror, 1, if the guilty verdict was an accurate statement about the verdict at the time, and 2, whether the verdict was based entirely on testimony, evidence, and law presented in the case, and 3, whether they heard Hill make any comment about the case before the verdict, and 4, whether the verdict was influenced in any way by any communications by Hill. Juror X, who testified on the first day of the hearing, acknowledged hearing Hill say before Murdaugh's testimony, "Looks like the defendant is going to testify. This is an important day, or this is an epic day, and that was rare for the defendant to testify." Juror X said these statements did not impact the verdict. Juror Z, who submitted one of the affidavits Murdaugh attached to this motion for a new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about the case, Juror Z responded that Hill said to watch his actions and to watch him closely. Juror Z added that Hill said more, but she could not remember anything else. Juror Z explained Hill's statements influencing her finding Murdaugh guilty because, to me, it felt like she made it seem like he was already guilty. At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn. Juror Z's affidavit gave a more detailed recitation of Hill's comments, saying, "Toward the end of the trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. She also instructed the jury to watch him closely immediately before he testified, including to look at his actions and look at his movements, which I understood to mean he was guilty." Juror Z testified that when the jury began deliberation, Hill told the jury this shouldn't take us long. In addition to referencing Hill's statements, Juror Z averred in her affidavit, "I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors." After reviewing the affidavit, the post-trial court questioned Juror Z, "I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court?" You answered that question yes. In light of what you said in the affidavit, which is, "I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors," is that answer that I just read a more accurate statement of how you felt? Juror Z answered affirmatively. The post-trial court then asked if she stood by the affidavit, and she answered yes. Juror Z subsequently submitted an affidavit to clarify her testimony, in which she explained that she felt influenced to find Murdaugh guilty by Hill's remarks before she entered the jury room. And once deliberations began, she felt additional pressure from the other jurors to reach a guilty verdict. Although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court. Juror Z answered affirmatively. The post-trial court... Juror P testified that on the day Murdaugh was to take the stand, Hill made a comment to watch his body language. He denied Hill comments influenced him in any way. Footnote 1. Following Juror Z's testimony, the post-trial court informed the parties that the other jurors who were waiting for their turn to testify had tuned in to the proceeding on court TV. The jurors either denied viewing the proceeding or, if they saw it, asserted it would not influence their testimony. In my personal opinion, that makes that entire jury invalid. They know they are not supposed to watch the proceeding. They were told to not watch the proceeding, and they did it anyway. The remaining jurors testified that they did not hear Hill make any comments about the case, and they were not influenced by any comments Hill made. Following the jurors' testimony, the state called Hill as a witness. Although Hill denied making most of the comments the jurors related, she admitted that on the day Murdaugh testified, and within earshot of some jurors, she spoke to the bailiff about Murdaugh's decision to testify. She also stated that she gave the jurors a little talk, instructed them to pay attention, and that day was a big day. She denied attempting to influence the jury. Now, way back when in one of my streams, we talked about these statements. If I don't misremember, the statute, the case law regarding influencing jury includes a bailiff, in a much older case, a bailiff who in passing said something negative about the defendant. That was enough for a new trial. So in all of this, folks, in all of this passing here is all that was needed for a new trial. And this case has a lot more. A lot more. In discussing her book, Behind the Doors of Justice, The Murdaugh Murders, footnote 2, as her book title suggests, it turns out Hill was quite busy behind the doors of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. The book was pulled from publications because Hill plagiarized portions of it. Hill claimed literally license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial did not matter to her. But she acknowledged as true a passage in which she stated she believed Murdaugh was guilty, but was concerned he would be acquitted because of his family's goodwill in the community. Jesus. The post-trial court also questioned Hill about the favors she granted the media. Hill denied allowing the press to view the exhibits, including the sealed exhibits. However, she subsequently pled guilty to perjury stemming from this denial. Although the post-trial court limited discussions of Juror 785, footnote 3, when the trial court dismissed Juror 785, she said her belongings left in the jury room included a dozen eggs, which another juror had brought her. She then became known as the egg juror or egg lady. Poor woman. She was gifted the eggs. She wasn't really the egg lady. The person bringing the eggs was the egg lady. There. From discussion of Euro 705, from whom the trial court dismissed on the day of deliberations began for allegedly discussing the case with third parties. Yeah, that was when Becky Hill lied about Juror 785 having discussed it with her ex-husband, stemming from a post on social media that her ex-husband supposed to have done. We found out that wasn't her ex-husband. She hasn't talked to her ex-husband in, 12 years, because she had a restraining order against him. Becky Hill lied to have her removed. Oh, they're going to go through that. It allowed Murdaugh to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed were from Juror 785's ex-husband. It wasn't a mistake. She lied. It was entirely manufactured. Hill claimed that Juror was very talkative while Hill walked her to the trial court chambers and volunteered that there was restraining orders on her ex-husband when they divorced. In response to the post-trial court's questioning, Hill continued to deny initiating or engaging the juror in discussion of these matters. In contrast to Hill's testimony, Juror 785 averred at the hearing before the trial court and in an affidavit Murdaugh attached to his motion for a new trial, footnote 4. Although the post-trial court did not allow Juror 785 to testify, her affidavit is in the record for our consideration. To his motion for new trial, that Hill interrogated her about the social media posts and whether she had been in contact with her ex-husband. In the affidavit, Juror 785 related that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement officers questioned the ex-husband about the post, offered to reinstate restraining orders Euro 785 had against him, and speculated that the Murdaughs probably got to the ex-husband when he called Euro 785 on the morning of the verdict. Euro 785 asserted Hill asked her whether she and the other jurors were inclined to vote guilty or not, and told her that everything Murdaugh said had been lies. She also stated that before Murdaugh testified, Hill told the jurors to not be fooled by the evidence Murdaugh's attorneys presented. Yeah, this was also lies. That cops went to her ex-husband. She made so much shit up. Rhonda McElveen, the Barnwell County Clerk of Court who assisted Hill with the trial, testified that Hill repeatedly told her she wanted to write a book so she could buy a lake house, and a guilty verdict would be the best way to sell books. McElveen testified that after Hill had given a juror a ride home. You're the clerk of court. You're not supposed to give jurors a ride home. McElveen counseled her that it was inappropriate, and while Hill admitted she gave the juror a ride, she claimed the bailiff was with them and they did not discuss the case. It doesn't fucking matter. Although McElveen did not hear Hill say anything inappropriate to the jurors, she stated that Hill made comments to her, staff, and media members strikingly similar to those jurors had reported, such as advising them not to be fooled by Murdaugh's attorneys and to look at Murdaugh's actions and movements while he testified. Finally, McElveen testified that Hill seated a writer with court personnel. This writer wrote the foreword for Hill's book. Hello, Dave. I accidentally hid somebody. Next, Murdaugh called the alternate juror to testify. She described the incident in which Hill made her comments before Murdaugh put up his case, stating that while the jurors were assembled in one of the two jury rooms, or were standing in the hall, Hill stood at the doorway and told them, "They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off." The alternate juror also testified that Hill told the jurors not to be nervous and don't be afraid to show your emotions because that's what they want to see. The alternate juror related she heard a court staff member say deliberations should not take long, but she could not remember who said it. Hey, Slidey. Good to have you here. Good to have you here. And hello, Christine, Dave, NetScholar, over at Rumble. Good to... Hey, the Rumble chat is full. Yay! Good to see you all. Hello, Mandy, Gwendolyn, Friend Psycho, Joni, Fire Red is here. Good to have you here, Fire Red. Autumn Dawn. Hello, folks. Denise Sells and everybody else who's here. Good to have you all here. Let's continue. In its order, the post-trial court declared the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. It then found Hill made improper comments to the jurors on the day Murdaugh testified, e.g., "This is an important day" or "This is an epic day," and that they should watch Murdaugh's body language. The post-trial court determined Hill's denial of making these statements was not credible. Hill's denials. Finding Hill wanted to write a book, which she believed a guilty verdict would help sell. She was attracted by the siren call of celebrity, and she allowed her desire for public attention of the moment to overcome her duty to her oath of office and her oath as a witness. Next, the trial court found that these comments did not affect any juror's verdict. It explained Juror Z's assertions that Hill's comments affected her verdict were ambivalent, self-contradictory, and not credible, emphasizing Juror Z had acknowledged a statement in her affidavit that she had voted guilty due to pressure from other jurors was the more accurate statement. The post-trial court further found that Hill's comments were limited in subject and not overt as to opinion, were only heard by at most 3 jurors, and were made in a case with overwhelming and compelling evidence, and that the trial court's extensive instructions cured any effect from these comments. The post-trial court concluded that while it found Murdaugh had failed to meet his burden to prove prejudice, any presumption of prejudice was overcome. It therefore denied Murdaugh's motion for a new trial. Murdaugh timely appealed to the Court of Appeals. This court certified the appeal of the denial of the motion for a new trial and subsequently consolidated it with a direct appeal. Law and analysis. Oh, this is the part I like. I like these parts. Murdaugh argues he was denied his constitutional right to a fair trial by an impartial jury free from outside influences. He asserts that following Remmer v. United States, prejudice should be presumed from Hill's comments to the jury, and that the presumption is irrebuttable. In the alternative, he contends the state failed to rebut the presumption of prejudice. The state argues the jury convicted Murdaugh, quote, because he was obviously guilty, and not because 3 jurors heard Hill's foolish and fleeting comment about his upcoming testimony. It contends that the post-trial court correctly declined to presume prejudice, and any presumption of prejudice was rebuttable. We agree with Murdaugh. Prejudice is presumed from Hill's comments, and while this presumption is rebuttable, the state failed to overcome this presumption. Our federal and state constitutions guarantee a criminal defendant the right to a fair trial by an impartial jury. Amendment 6, blah, blah, blah. Barnes and Joyner, Stockton v. Virginia, a lot of cases. This, quote, right can be infringed when a third party makes improper contact with the jury, for the right is meaningful only if the jury remains free from outside influence, including exposure to evidence or information that has not been introduced during the trial. State v. Green, Green 2. To protect the right to impartial jury in such cases, the Supreme Court of the United States created a rebuttable presumption of prejudice, the Remmer presumption, elucidating any private communication, contact, or tampering directly or indirectly with the jury during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, if not made in pursuance of known rules of the court and the instructions and directives of the court made during the trial, with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice to and hearing of the defendant, that such contact with the jury was harmless to the defendant. Remmer 1. The United States Court of Appeals for the Fourth Circuit noted that in addition to the presumption of prejudice, Remmer established a separate but related requirement that the defendant be entitled to a hearing when the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury. The Fourth Circuit established a 3-step test for considering extrajudicial contacts with the jury. The party who is attacking the verdict bears the initial burden of introducing competent evidence that the extrajudicial communications or contact were more than innocuous interventions. If this minimal standard is satisfied, the Remmer 1 presumption is triggered automatically. The burden then shifts to the prevailing party to prove that there exists no reasonable possibility that the jury's verdict was influenced by an improper communication. United States versus Sheik. The Fourth Circuit further provided that in determining whether the extrajudicial contact was innocuous or whether it triggered the presumption, the court considered whether it was 1. Any private communication, 2. Any private contact, 3. Any tampering, 4. Directly or indirectly with a jury trial, 5. About the matter before the jury. Quote, an unauthorized contact between a third party and a jury concerns the matter pending before the jury when it is of such a character as to reasonably draw into question the integrity of the verdict. That is Barnes quoting Stockton. So this is so established case law that there are numerous cases enforcing it. Numerous. Slidey Pie says over a rumble. Hill lady should be in jail. Yeah. She was. She pleaded guilty to a bunch of stuff, but she avoided jail altogether. Friends Psycho says, so the appeal is granted automatically. Yeah. The Supreme Court more or less had no choice. Once these were met, there's no question. Which also makes this case law. That none of these actions done by Hill is now included in the case law. Everything she did that this court said she did. So if it by any chance is somebody as stupid and corrupt as Becky Hill decides to do it again, they can refer to this case. No, you can't. Because each one of her comments is part of the case law. Each and every one. Individually and put together. Once the Remmer presumption is triggered, the state bears the heavy burden of proving there is no reasonable possibility that the verdict was affected by the contact. The court must examine the entire picture, including the factual circumstances and the impact on the juror. In determining whether the state met its burden of rebutting the Remmer presumption, courts consider a variety of factors such as the extent of the improper communication, the extent to which the communication was discussed and considered by the jury, the type of information communicated, the timing of the exposure, and the strength of the state's case. U.S. v. Basham and State v. Kelly. Relevant factors to be considered in determining whether outside influences had affected the jury and the number of jurors exposed, the weight of the evidence properly before the jury, and the likelihood that the curative measures were effective in reducing the prejudice. The extent of the communication is the most important factor. In Parker v. Gladden, another case. You see how many cases there are in South Carolina alone and other places that explicitly addresses this. It is to tell other courts, stop doing this shit. We don't want to hear about this shit. It will be a new trial if you fuck up this bad. They were talking about the case, which I just... In Parker v. Gladden, the Supreme Court recognized the extreme prejudice inherent in statements concerning the matter at trial when made by an officer of the court. Footnote 6. The Supreme Court did not apply the Remmer analysis. Yeah, so they didn't even need to apply the Remmer analysis. They just concluded, yeah, this is fucked up. There, a bailiff who oversaw a sequestered jury during an 8-day trial stated to a juror in the presence of other jurors, "Oh, what a wicked fellow. He's guilty." Oh, so okay, so it had more than I remembered. The bailiff also told another jury, if there's anything wrong in finding the petitioner guilty, the Supreme Court will correct it. At least one juror, or alternate, overheard the statements. In rejecting the state's argument that no prejudice was shown, the Supreme Court explained, this argument overlooks the fact that the official character of the bailiff, as an officer of the court as well as the state, beyond question carries a great weight with the jury which he had been shepherding for 8 days and nights. Although the Supreme Court noted the 26-hour jury deliberations and one juror's testimony she was prejudiced also supported the trial court's finding of prejudice, it held that the unauthorized conduct of the bailiff involved such a probability that prejudice will result that it is deemed inherently lacking in due process. It further recognized that it would be blinking reality not to recognize the extreme prejudice inherent in such statement that reached at least 3 members of the jury and 1 alternate member. Here it means it's extra bad that it's an officer of the court that is doing these remarks. Extra bad. because they are the court. They are the prolonged arm of the judge, who is presumed unbiased, which makes it extra vile. However, not all comments by officers of the court are prejudicial. In Green, a juror asked the bailiff what would happen in the event of a deadlock, and he responded the judge would likely give them an Allen charge and asked if they could stay later. While the Court of Appeals held the state overcame the Remmer presumption, this court held the bailiff's comments did not trigger the presumption. We explained that our unwillingness to categorically apply the Remmer presumption of prejudice stem from our view that not every inappropriate comment by a bailiff to a jury rises to the level of constitutional error. As the Fourth Court recognized, there is a split among the circuits regarding the issue whether the Remmer presumption has survived intact following the Supreme Court decision in Smith v. Phillips, Olano, and Lawson. Collecting cases and recognizing the split in the circuits. In Phillips, the Supreme Court declined to impute bias to a juror who applied for a job in the prosecutor's office during the Phillips trial. In reversing the grant of federal habeas relief, the Supreme Court declared that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. The court explained that due process do not require a new trial every time a juror has been placed in a potentially compromising situation. Instead, due process necessitates a jury capable and willing to decide the case solely on the evidence before it, and a trial judge ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. Footnote 7 is Allen v. US. Footnote 8 is in both Phillips and Olano, the Supreme Court noted that cases' procedural postures informed the outcomes. Phillips, of equal importance, this case is a federal habeas action in which the trial court's findings are presumptively correct under the rules, applying plain error standard because Olano did not object to the alternate juror's presence in the jury room. The Court of Appeals should correct a plain forfeited error affecting substantial rights if error seriously affects the fairness, integrity, or public reputation of judicial proceeding. Okay. In Olano, the Supreme Court considered whether the presence of alternate jurors during jury deliberations was plain error that the Court of Appeals was authorized to correct under Federal Rule of Criminal Procedure, noting the alternate juror's presence was not the type of error that affected substantial rights independent of its prejudicial impact. The court found no reason to presume prejudice. It explained, there may be cases where an intrusion should be presumed prejudicial, but a presumption of prejudice as opposed to a specific analysis does not change the ultimate inquiry. Did the intrusion affect the jury's deliberation and thereby its verdict? Which means the mere presence of an alternate in the jury room that is not deliberating is not enough to presume prejudice. I assume that is because they are still bound by the rules that not be affected and all of that. Neither Phillips nor Olano expressly overruled the Remmer presumption. Indeed, in Olano, the court specifically recognized that prejudice should be presumed from certain intrusions, just not from alternate jurors who have been properly instructed not to deliberate, sitting in on the deliberation of a jury. The Fourth Circuit rejected the argument that the Supreme Court overturned the Remmer presumption of prejudice attached to extrajudicial communications with the jury, declaring the presumption remained alive and well in the Fourth Circuit. See Barnes, noting the Remmer presumption is clearly established federal law, even after the Supreme Court's decision in Phillips and Olano. Concluding North Carolina State Court's adjudication of Barnes' jury misconduct claim, without allowing a hearing on the claim or following the Remmer presumption, amounted to an unreasonable application of clearly established federal law. Jenkins v. State. While Phillips and Olano may somewhat limit the scope of presumption prejudice, they do not preclude such a presumption in all situations, i.e., where excessive or egregious jury misconduct or improper conduct by a third party occurs. The Fourth Circuit explained the remnant's presumption applies in cases where the danger is not one of jury impairment or predisposition, but rather the effect of an extraneous communication upon the deliberative process of the jury. Thus, the distinction between internal and external jury influences is critical because, unlike external influences, which necessitate a thorough judicial inquiry, no such obligation is imposed with regard to an internal jury influence. And yeah, it goes on and on. I mean, there's so much case law regarding this. It is the courts over and over again telling lower courts to stop doing this. We don't want these cases because there are obvious rules, obvious case law in place already. Stop doing this shit. For fuck's sake. All right. Under this framework, we turn to the facts at hand. First, we must determine which comments Hill made to the jurors. The post-trial court referenced only a few of the comments the jurors testified she made, e.g., this is an important day or this is an epic day, and to watch Murdaugh's body language. The state argues the post-trial court implicitly rejected the other alleged comments as not being credible. We find this argument is without merit. The post-trial court gave no indication it found the other comments not credible, nor would the record support such a finding. Indeed, the post-trial court found Hill's denial of making any inappropriate comments lacked credibility. Footnote 10. Hill's lack of credibility during the hearing on Murdaugh's motion for new trial is further evidenced by her recent guilty plea to perjury, stemming from the hearing for her denial allowing members of the press to view the sealed exhibits. Yeah, fuck you, Hill. The post-trial court made no distinction regarding the comments it referenced in its order, and the remaining comments that are in the record. The post-trial court, in fact, found credible juror Z affidavit statements concerning pressure from other jurors. This same affidavit included juror Z's recollection of Hill's comments not to be fooled by the evidence presented by Murdaugh's attorneys, and his instructions to watch Murdaugh closely, look at his actions, and look at his movements. The state offers no rationale for finding part of the affidavit credible while rejecting the portions that are damaging to the state's case. Juror Z's recollection of Hill's comments was consistent with Juror 785's affidavit testimony that Hill told the jurors not to be fooled by the evidence Murdaugh defense presented. Juror Z's recollection is also consistent with the alternate juror's testimony concerning Hill's comments. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Footnote 11. The post-trial court did not make a finding on the alternate juror's credibility. Ta-da! These comments were also strikingly similar to the comments Hill made to McIlveen, other staff members, and the media when away from the jury. Furthermore, Hill's attempt to insert herself into the jury deliberations through these comments was in line with her stated desire for a guilty verdict to sell more copies of the book she planned to write. Her meddling in events around Juror 785's dismissal, her self-aggrandizing conduct throughout and after the trial, from granting favors to media members, such as allowing them to view sealed exhibits and sitting a writer with court staff in the courtroom to granting interviews. As the post-trial court found, quote, Hill was attracted by the siren call of celebrity and, quote, allowed her desire for the public attention of the movement to overcome her duty to her oath of office. We have no reason to find Hill did not make all of the statements the jurors reported. Therefore, we hold Murdaugh established Hill made comments that the day Murdaugh testified was epic or important, and urged the jurors not to be fooled, confused, thrown off, or convinced by Murdaugh, and to watch Murdaugh's body language closely. Next, we must decide whether these comments were more than innocuous interventions. And then they cite a lot of case law. Our following consideration is whether the statement is heavy burden of proving there is no reasonable possibility that the verdict was affected by Hill's comments. As stated above, the post-trial court analyzed the evidence before it by erroneously imposing the burden of proof of prejudice on Murdaugh. Yeah, burden shifting. Prior judge didn't apply the right standard, which was exactly what the Murdaugh team said. Furthermore, as Murdaugh argues, the post-trial court erred in considering testimony from the jurors about whether Hill's comments affected their verdict because this testimony violated Rule 606B of the South Carolina Rules of Evidence. Rule 606B limits the testimony a jury may give on the issue of prejudice. This rule provides, upon an inquiry into the validity of a verdict or indictment, a jury may not testify as to any matter or statements occurring during the course of the jury's deliberations, or to the effect of anything upon that or any other jury's mind or emotion as influencing the juror to assent or to dissent from the verdict of or indictment or concerning the juror's mental processes in connection therewith, except that a jury may testify on the question whether extraneous prejudicial information was improperly brought to the jury's attention, or whether any outside influence was improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the jury concerning a matter about which the juror would be precluded from testifying be received for these purposes. In interpreting court rules, this court applies the same rules of construction used to interpret statutes. Thus, if a rule's language is plain, unambiguous, and conveys a clear meaning, interpretation is necessary, and the stated meaning should be enforced. I.d., we must consider not only the particular clause in which a word may be used, but the word and its meaning in conjunction with the purpose of the whole rule and the policy of the rules. I.d., in addition, when a South Carolina rule is substantially the same as its federal counterpart, we may consider federal cases in interpreting the rules, which they are doing. And then U.S. Supreme Court explained Federal Rules of Evidence 606B. And let's get to the conclusion here. Footnote 12. We recognize that in the... Yeah. Okay. This right was not Murdaugh's to waive. Thus, the portion of Josette's affidavit in which she disclosed her mental process in reaching her verdict was inadmissible. The post-trial court erred in questioning her about the portion about that portion of the affidavit, and the post-trial court should not have considered that portion in ruling on the new trial motion. We also hold the post-trial court erred in finding a lack of prejudice because Hill's comments were limited in subject and not overt as to opinion, were only heard by at most 3 jurors, and were made in a case with overwhelming and compelling evidence. We reiterate, the burden is to the state to rebut the presumption of prejudice. First, the post-trial court erred in finding Hill's comments were limited in subject and not overt as to opinion. Hill clearly advised the jurors to find Murdaugh and the evidence he presented not credible, and essentially urged them to render a guilty verdict. Hill's position as the Colleton County Clerk of Court, an officer of the court who managed the trial and was the primary caretaker of the jury, amplified the impact Hill's comments had on the jury. Next, the limited number of jurors who acknowledged. This is important here. Who acknowledged. This means the Supreme Court is basically saying the other jurors are not credible in saying they didn't hear anything. The limited number of jurors who acknowledged hearing Hill's improper comments did not reduce their prejudicial effect. As the Supreme Court explained, a criminal defendant is entitled to be tried by 12, not 9 or even 10, impartial and unprejudiced jurors. In addition, in the context of the jury tainted by external influences, the strength of the state's case does not necessarily warrant a finding that the state met its burden of proving a lack of prejudice. The state certainly produced considerable evidence here, and arguably, reasonable minds may debate whether the evidence here was overwhelming. In the situation before us, notwithstanding the strength of the prosecution's case, the state is unable to overcome the presumption of prejudice. The state's case rested largely on circumstantial evidence, and Murdaugh's credibility was a key component of his defense. Hill's repeated comments challenging Murdaugh's credibility directly undermined that defense. His egregious, improper jury interference went to the heart of the case and unquestionably was intended to push the jury to a guilty verdict. The focus of the harmless error inquiry is not on the sufficiency of the evidence absent the error, but rather the impact of the error on the jury's verdict. The breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina. Meaning, this is so far beyond the case law and the statute we already had that we don't get why this even got to us. This should have been clear to post-trial court. Finally, we hold the state has not met its burden of proving the trial court's instructions to the jury cured any prejudice arising from Hill's comments. Generally, an instruction to disregard incompetent evidence is deemed to have cured the error. Moreover, jurors are presumed to follow the law as instructed to them. Holding that any prejudice caused by the alternate jurors' presence in the jury room, they're talking about this Grovenstein case. Here, the trial court gave the standard instructions and admonishments to the jury, none of which provided guidance on what to do when Colleton County Clerk of Court, an officer of the court, made comments disparaging Murdaugh's credibility and urging the jury to reject his defense. The trial court never had the opportunity to even attempt to cure the prejudicial effect of Hill's comments because they did not come to light until months after the trial. If we were to accept the proposition that standard charges could cure such prejudice, then no defendant would be entitled to relief when improper extrajudicial information reaches the juror's ears, regardless of its content or context. Our federal and state constitutions simply cannot countenance such an assault on the right to a fair and impartial jury. Judge Newman needs to be fine. Judge Newman has retired and nothing will happen to him because of more or less absolute immunity. How you kitty book? In summation, Murdaugh met his initial burden of establishing Hill's comments to the jury were more than innocuous interventions, triggering the Remmer presumption of prejudice and shifting the burden to the state. The state simply was unable to meet this heavy burden of proving that there exists no reasonable possibility that the jury's verdict was influenced by these highly improper comments. See, chic. To implement the heavy obligation of the party who seeks to rebut the presumption of prejudice, we have prescribed that the proof must establish that there was no reasonable possibility that the verdict was affected by the contact. Basically meaning the state had to show this beyond reasonable doubt. The same bar as to convict a person. Accordingly, we hold Murdaugh's right to a fair trial by an impartial jury was violated, and the post-trial court erred in denying his motion for a new trial. Now, folks, this here, what we are getting to now, this is what affects the new trial. What they're going to go into now is how much other shit is a court allowed to bring in to show that a person is generally a bad guy. This is... Now, what we've just read is what... Yeah, it's obvious. Obvious to any person with a law degree that Murdaugh should have a new trial. Any person with a law degree that for the past 2 years have said, here, it's not enough, big Becky boo, oh, yada, yada, yada. Fuck you. Return your bar card immediately and go do something else. Because this isn't only obvious that Murdaugh should have a new trial. It's overly obvious to the extent that this is, as they said, in South Carolina, this conduct is unprecedented. This goes so much beyond, that the Supreme Court is basically saying, why the fuck are we seeing this case when the case law is this obvious? Why did it have to go to us when this should have been handled in lower courts? It's that bad. So every judge, every attorney who handled this case or commenting online, return your bar card immediately. You're a disgrace. Every single one of you are a disgrace. Every person with a law degree who defended Becky Hill, even after she pled guilty to perjuring herself, return your bar card. You're a disgrace. Okay, let's go into it. Evidence of Murdaugh's financial crimes. Because we order a new trial on the basis of Hill's improper influence on the jury on appeal from the order denying Murdaugh's motion for a new trial, it is not necessary that we address the evidentiary issue Murdaugh raises on appeal from his conviction and sentences. We elect, however, to offer the trial court on remand the following guidance regarding the admissibility of evidence of Murdaugh's financial crimes. This is the Supreme Court of South Carolina telling the lower court, we don't want to see this fucking case again. Stop doing stupid shit. Stop making stupid rulings. We don't want to see this again. So here is some guidance, which is legal speak for stop doing stupid shit. At the time of the trial, Murdaugh had been accused of and indicted for numerous financial crimes. During his testimony before the jury, Murdaugh admitted he committed the financial crimes, although he had not at that time been convicted of anything. After trial, he pled guilty to the financial crimes in both state and federal court. He was sentenced to concurrent 27 years in state prison and 40 years in federal prison. The state sought to admit evidence of these financial crimes during Murdaugh's murder trial for the purpose of showing his motive for committing the murders. The state filed a pre-trial motion in which it argued the evidence demonstrated Murdaugh accrued substantial debts over a period of years, and to cover those debts began engaging in illicit financial crimes involving the theft and misappropriation of money from his clients and his own firm. The state emphasized that several series of events unfolding in the weeks and days leading up to the murders threatened to expose Murdaugh's financial crimes. The state wrote in its motion, quote, all of these factors start to converge on June 7, 2021, the date of the murders. The state explained its motive theory. The murder served as Murdaugh's means to shift the focus away from himself and buy himself some additional time to try and prevent his financial crimes from being uncovered. The state also stressed Murdaugh's attempt to cover his financial misdeeds after the murders to supply its theory of motive. Murdaugh filed a memorandum arguing that financial crime evidence should be excluded under Rules 402, 403, and 404b. Footnote 13. In addition to Murdaugh's challenge to the trial court's decision to admit evidence of his financial crimes, Murdaugh appealed the trial court's decision to 1. Allow the state to question a witness on redirect examination about the witness's knowledge of Murdaugh's financial situation. 2. Admit evidence of firearm and tool mark analysis expert testimony. 3. Admit evidence of 4 firearms seized from the cell. 4. Admit evidence of a blue raincoat collected from the home of Murdaugh's mother and gunshot residue expert testimony related to that raincoat. 5. Allow the state to question Murdaugh on cross-examination as to the reasons he did not reveal until trial his presence at the kennels of the night of the murders. And 6. Admit evidence of an iPhone demonstrating during the state's rebuttal case. All right. The trial court conducted a lengthy pre-trial hearing, but declined to rule on the admissibility of the financial crimes evidence at that time. During various breaks in the course of the trial, the state presented the testimony of 8 witnesses regarding Murdaugh's financial crimes outside the presence of the jury. After hearing this testimony and arguments of both sides, the trial court found, quote, all evidence of financial crimes that may likely have led to a motive or lend itself to motive for the crime committed was admissible. The trial court stated the jury was, quote, entitled to consider whether the apparent desperation of Mr. Murdaugh because of his dire financial situation, threat of being exposed for committing the crimes for which he was later charged with, resulted in the commission of the alleged crimes. The trial court also found the evidence of other crimes is admissible and its non-propensity, and it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground than the specific charge. What an... Folks. A person may be charged of 100 crimes. He might be guilty of 99 of them. But the last one, he might be innocent. That is why don't bring in shit that says he's an absolute garbage human being. Do not do it. Because the strength of the case in this murder case should stand on its own. Do not bring in the fluff. Allow the jury to reach a verdict on the case itself, on the evidence you present to the jury. It really isn't that hard. It is what you're supposed to do. Contrary, in my opinion, this shows that the state did not believe they could convict Alec Murdaugh on the murder case alone. Let's continue. The trial court found the evidence has sufficient probative value that was not substantially outweighed by any danger of unfair prejudice. The trial court issued a written order setting forth its ruling. Footnote 14. The 8 witnesses who testified outside the jury's presence was Janine Seckinger, Michael Gunn, attorney Chris Wilson, yada, yada, yada. The state then presented testimony to the jury from 8 witnesses who testified earlier, along with 2 additional witnesses. Through these witnesses, the state proved Murdaugh committed wide-ranging financial crimes over numerous years in several general categories, including the following. Murdaugh stole money from his clients by billing personal expenses to them under the guise of those expenses being costs associated with their cases. Murdaugh stole money from his law firm by instructing law firm employees to make checks payable to Palmetto State Bank, whose then Chief Executive Officer Russell Lafitte enabled Murdaugh to convert the funds for his personal use. Murdaugh stole money from his clients and his law firm by instructing law firm employees to make checks payable to forge a fake account Murdaugh had created to imitate the legitimate Forge Consulting LLC firm. Yada, yada, yada. Yeah. In my personal opinion, Alec Murdaugh's law firm knew or should have known that this has been going on for years, and so not just pretended not to notice, because one general audit of the financials would have discovered this over a decade before anything that happened. It is so overly obvious, and so this is what he did is so easily discoverable that just a simple audit would have discovered it. They chose not to find it. Can I prove it? No, I don't have to. I'm just Santa Claus making opinions. The state also presented evidence to the jury that Murdaugh's years of stealing money in these ways were about to be exposed. For example, law firm employees testified they asked Murdaugh on at least 2 occasions in the weeks leading up to the murders about discrepancies in his financial disbursement documents in individual cases. Janine Seckinger, the firm's chief financial officer, testified she confronted Murdaugh on the morning of the murder, stating, "I have reason to believe you received attorney's fees in a certain case directly to you, and you need to prove to me that you did not." Other evidence indicated Seckinger were referring to $792,000 in missing attorney's fees the firm was supposed to receive from Murdaugh's co-counsel, Chris Wilson. The state also presented evidence that Mark Tinsley, the attorney representing the family of the young woman who died in the boat wreck, had scheduled a motion hearing for 3 days after the murders, in which Tinsley sought to compel Murdaugh to disclose his detailed financial records. Murdaugh challenges the admissibility of evidence of his financial crimes under 401, 402, 403, and 404B. As to Murdaugh's relevance objection, the state argues that because Murdaugh was charged with murdering his wife and son, quote, seemingly inexplainable and inexplicable conduct when standing alone, it was important that it offer evidence to explain why he did it. The state also argues Murdaugh himself placed the issue of motive front and center through his own actions by suggesting to officers who arrived at Moselle on June 7th that the killer's motive stemmed from the boat wreck. We agree with the state that evidence of Murdaugh's financial crime made the state's theory of motive more probable. See State v. White and State v. Sweat. Thus, we find the trial court acted within its discretion in finding the financial crime evidence was relevant under Rule 401 and admissible under 402. The more difficult question is whether the trial court should have excluded all or some of the financial crime evidence pursuant to Rule 404B or Rule 403. We address this question as 2 distinct categories of issues. The first of these categories, whether the trial court should have excluded all the financial crimes evidence, is a point on which not all members of the court would have ruled the same way had we been the trial court. We each agree, however, this was a decision within the discretion of the trial court under the facts and circumstances that existed in Murdaugh's trial. As to the second category, we will address whether the trial court should have restricted the extent of which the state was allowed to present this evidence, that is, whether the trial court should have excluded some of the evidence. We unanimously hold that the trial court allowed the state to go far too long and far too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory or motive, which gave rise to considerable danger of unfair prejudice, and therefore should have been excluded. As to whether the trial court should have excluded all evidence of Murdaugh's financial crimes under 403 and 404, we have discussed the principles applicable when a trial court is asked to exclude evidence in other crimes in numerous cases, and no further elaboration of those principles is necessary here. And then they cite a plethora of cases. As to Rule 404b, the difficulty lies in the application of these principles to the facts and circumstances of any individual case. Here, the trial court correctly understood the applicable principles of law and thoughtfully applied those principles to the facts and circumstances before it. The trial court explained its view of the logical connection between the financial crimes and Murdaugh's motive. The state's argument that it presented a valid theory of motive, and Murdaugh's response that the fabricated motive theory is illogical, implausible, and not supported by evidence, was not a dispute for the trial court to resolve by making this evidentiary ruling. That was for the jury. The trial court's job was to determine, in its discretion, whether the state's theory of motive was reasonable, plausible, and if so, whether the evidence the state presented could reasonably support the theory. We agree with the state that, under the factors and circumstances in existence in Murdaugh's first trial, the trial court acted within its discretion in deciding not to exclude the evidence under 404b. As to 403, the trial court balanced the probative value of the evidence against its potential for unfair prejudice and concluded the probative value was not substantially outweighed by any unfair prejudice. The trial court specifically found Murdaugh's commission of the financial crimes does not suggest to the jury the defendant has a tendency to commit murder. As we will discuss below, we found considerable unfair prejudice in allowing the state to go as far and deep into detail as it did. However, we hold that the trial court, within its discretion, in admitting some evidence of Murdaugh's financial crimes. When the trial court's thought process of applying some principles of law to the court's view of the facts and circumstances is evident in the record of proceeding in a hearing, the appellate court will defer to the trial court's exercise of discretion, even when the judges on the appellate court might have made the decision differently. We emphasize, however, the trial court should have limited the state's presentation of this evidence. We illustrate this point with an example from the direct examination of Tony Satterfield. State, why were you the personal representative and not your brother? Satterfield, because my brother is a vulnerable adult and he has a disability. Court, can you repeat those words for me? That my brother is a vulnerable adult and is not able to function as a normal human being to deal with stuff like that. State, is a vulnerable adult? Satterfield, yes. This particular testimony had zero probative value as to Murdaugh's motive for the murders, and obviously high potential for unfair prejudice, as it portrays Murdaugh as a man who preys on vulnerable victims. See Rule of 403. Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Much of the additional details the state presented as to Murdaugh's financial crimes had little or no probative value for the purpose of establishing Murdaugh's motive. The state's theory of motive centers on the point that his financial crimes were about to be exposed, and he needed time. The fact he committed some of those crimes against a vulnerable adult adds nothing to the theory. To the extent many similar details may have had minimal probative value, that value is substantially outweighed by the unfairly prejudicial sympathy the jury was likely to feel toward the victim. By our calculation, the state spent a total of 12.5 hours of actual testimony before the jury over 10 days of trial to introduce evidence related to Murdaugh's financial crimes. We are convinced the state could have effectively presented evidence to support its motive theory in a fraction of that time. By holding the trial court in this case acted within its discretion in admitting some evidence of Murdaugh's financial crimes, we certainly do not intend to require the evidence to be admitted on retrial. As often is the case, the facts and circumstances of retrial may be materially different from those presented in the initial trial. Thus, the trial court on remand must do as the trial court did here, carefully and thoughtfully apply correct principles of law to the facts and circumstances before it. We do intend to require, however, that if the trial court decides to admit evidence of Murdaugh's financial crimes on retrial, the state must complete its introduction of that evidence efficiently, without a lengthy presentation of inflammatory details with little to no probative value that was permitted in the first trial. No sob stories. That is basically what this concludes to. No sob stories. You can, yeah, he stole money. How much? This much. He was about to be discovered with it. Boom, done. Not 12 and a half hours of sob stories. Conclusion. As the Fourth Circuit declared, the Remmer presumption is alive and well. It serves to protect the right to a fair trial by an impartial jury for all defendants. Here, Hill, the Colleton County Clerk of Court, egregiously attacked Murdaugh's credibility and his defense, thus triggering the presumption of prejudice, which the state was unable to rebut. As noted at the outset, Hill's shocking jury interference was accomplished outside the presence and knowledge of the outstanding trial judge and superbly competent and professional counsel for the state and the defense. We are accordingly constrained to reverse the post-trial court's denial of Murdaugh's motion and remand for a new trial consistent with this opinion. Reversed and remanded. And final footnote. We commend the post-trial court, which inherited Murdaugh's motion for a new trial and was placed in the unenviable position of evaluating unprecedented jury interference by a court clerk within the context of a murky area of law. Yeah, I remember saying at the time it was obvious for the post-trial court they wanted this to be decided by the Supreme Court. But the Supreme Court also says it should never have reached us, because this is so much beyond everything that is already established in South Carolina. It should never have reached us. So that was the Murdaugh case. Now, folks, in my opinion regarding the Murdaugh case, if it were to stand on the actual evidence, there are many, many damning things against Alec in that case. Many, many. Except one thing. His wife's phone was still moving when he was not there. Provably was not there. He was provably a mile away when her phone stopped moving. Provably a mile away. The state didn't even contend. That's when they put in, the guy who threw the phone around his office, which should never have been admitted as evidence. Never. How the fuck do you cross-examine such garbage? For me, that is equal to the Delphi case, when they took in an expert who Googled to reply to the fact that Abby's phone was tampered with at 5:40 p.m. long after the girls were supposedly dead. Long after. And then we have other crap like, for the state's theory to be correct regarding how Paul was killed, how they claimed he was killed by Alec's Alex shotgun, that angle, for that angle to be correct and that spread to be correct, the butt of the shotgun would have been a foot underground. So there are questions, but it's going to be a new trial, and we have to wait and see. Will I cover it? Yeah, I will. Gavel to gavel. Now we are back in that trial. Alec Murdaugh is back to be presumed innocent. There will be a lot of pre-trial motions, a lot of pre-trial hearings, a lot of them. I would say we are 2 years from that trial to start. Because it took 2 years for them to get to the first trial. It will be interesting. It will be interesting. Now, folks, let's get to the snarky stuff. Let's get ourselves to Kouri Richins. Now, the sentencing, there were a lot before Kouri started to spew her garbage. We found out, and my hats off to Mr. Prosecutor Bloodworth, because the boys, the sons, eradicated Kouri Richins' attempt of an alibi completely. They would have testified in court that no, Kouri did not go to sleep in one of the boys' rooms because of night terrors. In fact, she locked the door to the bedroom, had the TV on loud music, actively hindering the boys to enter the bedroom. They were put to bed much earlier than normally. We found out that during the sentencing hearing. We also found out that Kouri Richins has an admirer that she had communications with. She got letters sent into court and somehow read to court by people who have never met her. I have no idea why that was omitted. Maybe it was judge saying, sure, let's hear what this idiot is writing. Some of it, the heartbreak of the Richins family. But my hat's off to Mr. Bloodworth for actively weakening his case to protect the boys. Now, there's a clear chance that he was, for the oldest of the boys, to have him as a rebuttal witness in the rebuttal case. Because the defense knew that he was to eradicate. And we have a bot over at Kick. Go fuck yourself. Oh, I hate it. I hate it. I hate it. I hate it. Mute. And I hate these bots with an absolute. I'm not joking here. Let's see here. How to Sorry for... Why is it not... This is... They have a staff? Verified? Okay, I'm never going to stream on Kick again. Never. If Kick are actively allowing fucking bots to spew shit in my chat over at Kick, then fuck you, Kick. Fuck you all the way to hell. Fuck you. Sorry for the people who are watching over there, but I am removing Kick. Boom. Boom, gone. Ta-da. Yeah. For love of fuck, how in the absolute shit, how can you be such a moron that you allow bots on Kick by staff? No, not staff. Kick itself manufactures bots to spew shit in the chat. How can you be so immensely moronic? No. I return because why not? To make one stream over at Kick. Never going to happen again. Never. All right, folks. With that taken care of, hello. For you who have heard me before, you are not surprised about my opinions regarding bots. The people who program bots, the people who buy bots, you're nothing. Born nothing, am nothing, remain nothing. You have no worth to me whatsoever. None whatsoever. All right, folks. Now to the fun stuff. Well, let's see if it's fun. Yeah, tune in just in time for the Kick rant. Yeah. Never going to stream there again. Never. All right, folks. Kouri Richins sentencing. Let's go. Okay. You have sound?
On the record. This is case 231-500-139. Ms. Lewis, Ms. Nestor, anything further before we hear from Ms. Richins?
No, Your
Okay. I understand that Ms. Richins will like to stand at the podium.
Yes, Your Honor.
And you folks would like to join her?
Yes, Your Honor.
No problem.
Sure.
There should be Kleenex up there if you need it.
Is your do you want water? Maybe. My sweet baby boys. I know that today you don't want to speak to me, have a relationship with me, or you may think you hate me, and that's okay. I will never be angry at you for your feelings. When the day comes that you're ready, I will be here for you, waiting for you, and loving you. But I need you boys to know and understand that I have been desperately trying to get in contact with you any way that I can for years. That all of my communication has been completely cut off from you since early 2024. And now I will use any opportunity I can to get a message to you. Even if that means sharing it publicly to the world, fully restrained, in my jail clothes, in one of the most horrible situations possible.
You piece of human garbage. You already know what your boys think of you. And you still won't leave them alone. This is bordering on witness intimidation. This is bordering on witness intimidation.
I don't care, and I'm not embarrassed or ashamed by any of it. All I care about is you boys. I will do whatever it takes for you to hear the truth from me and to come home to you. For the time being, I don't know when that is or when my next opportunity will be. So for now, bear with me as I have tried to consolidate everything I've wanted to share with you for the last few years, with everything I want you to know until I'm able to speak to you again in one long message. And although you may not be ready to hear it today, that's okay. My hope is one day you will be. May 6th of 2024, temporary custody was transferred from the state of Utah Child Services to your Aunt Katie and Uncle Clint. My last video call with you boys was several weeks prior to that, around April 24th, 2024, when you were still in the state's custody. Once temporary custody was transferred to Katie and Clint, against my wishes, they cut off all of my communication between you.
Your wishes are worthless. You were charged with murder. You have zero rights to your boys.
Boys and I. It was years before I would ever have a trial. I warned social services that if they gave custody of you to the Richins family, it would be the last time I would be able to see or speak to you boys again.
That's not a warning. That is people doing the right thing to stop you from hurting people.
And your opinion of me in this case and wild allegations would soon mirror those of the Richins family. And that's exactly what happened. You need to know the Darden side of the family fought a long, hard battle for custody, but was eventually ignored and denied. Since temporary custody was granted to Katie and Clint, they have not allowed me to see or speak to you. No more video calls, no more visits. They blocked the phone number for the jail so I can't call you.
Protective order. Remember, folks, she took out life insurance on the boys as well. Like she did towards the dad, who she murdered to get money. That is a serious, serious threat.
Birthday cards, Christmas cards, the letters I would send you boys, they were all returned or rerouted.
Because you couldn't stop trying to influence them. You are a piece of human garbage who should never see the light of day again. You have no right to the voice. None whatsoever.
All of my contact was cut off more than 2 years ago. So please ask them. Please ask them for your cards, for your letters, if I tried calling you. Please just ask them, whether it's now or in 10 years. The one thing I need you boys to know is I did not abandon you. I did not just walk out of your lives one day to never return, to never call, to never...
They are perfectly aware how and why you disappeared. Folks, in this hearing, an hour prior or so, they expressed their eternal gratitude of never seeing you again. They expressed their utmost thank you to the state for protecting them. They don't care where you are, as long as you cannot see them or hurt them anymore.
Show up. Regardless of what anyone tells you, I would never ever leave you boys. And I am so sorry if for even 1 second you thought that I did. If for even 1 second you thought that I didn't love you. Because that couldn't be further from the truth.
Don't believe her. For her, they were just assets. A bargaining chip. Because your husband, who you murdered, knew that if he were to leave you, there was high risk that you would have some form of custody and that you would hurt the boys. So he stayed. And he got murdered.
You boys are my world. The reason I continue to wake up every day and fight to come home. You're my reason for living. I understand that you're in a difficult situation. Mentally, emotionally, and physically.
No, they were taken away from it, from you. They are now safe.
I understand you guys have been through an extremely difficult time this past 4 years.
Yeah, because you killed their dad, asshole. You made this situation happen, Kouri. It's all you. Everything that these boys suffered is because of you.
You should never have to deal with such tragedy. And I am
No. But you put it on them by killing their dad.
so sorry that you were going through this. You boys have the right to be angry and sad and confused, feel in survival mode, have questions. All of this is completely valid. Your feelings are completely valid. And one day when this is all over, we can sit down and talk about all of this.
You will never see the outside of a prison for the remainder of your days. Never. Never, never, never. Your appeals will be fruitless. I watched this entire trial. Were there mistakes? Extremely minor ones.
And sort it all out. And I promise you boys one day it will be over. I'm not perfect. I have succeeded and I have failed. As a person, as a wife, as a parent, we all do. I have done plenty of things I am not proud of. Some I regret, some I don't. Some I'm ashamed of, and some I'm not. I regret things I have done right in my life to later find out they were for the wrong people. I have said things I shouldn't have. I've done things I shouldn't have. Sometimes I haven't said what I should or not meant what I did say. There are things I can't change and long overdue apologies that I owe. There are would-haves and could-haves and should-haves. We all have them. We have all done them. And you boys will too one day, but in your own way. And that's okay. That's life, and we're human. Nobody is all good or all bad. We just get portrayed that way. You're going to succeed and achieve amazing things in this life. You're also going to make mistakes and fail at some things. But use those opportunities to grow and to learn. They do not define you, and don't ever let other people make you think that they do. We are not defined by our best or our worst moments. We fall somewhere in the middle, ever evolving. And you boys are ever evolving. Secrets diminish self-respect. They lose trust. They make us lose ourselves. I fell in love with someone who wasn't your dad. Your dad fell in love with someone who wasn't me. I did things behind your dad's back. He did things behind mine.
No, he didn't. You cheated. You stole. And then you killed him. You tried to claim that he had a gay relation. No, asshole. He did not do things behind your back. He didn't. He had no affairs. He went on hunting trips. By all accounts, once the boys were old enough, he would have brought them with him to his hobbies. It's an interesting hobby, but still it's a hobby. You cheated on him. You stole from him. You stole basically through your actions. You were prepared to put your entire family into bankruptcy for the illusion of success. You were prepared basically to make your sons homeless because you wanted to act like a successful person. He did nothing to you to deserve what you did to him and what you did to your sons. Nothing.
Don't keep secrets. Always put your spouse first. Your dad and I didn't always do this, but don't be like us in that aspect. We made mistakes that I know I regret, and I'm sure if he were here today, he would say that there are a few things he regrets as well. Marriage is hard. Marriage takes work. Marriage takes love. Big love. Deep love. And you may think about divorce, and you will have fights, but then you will make up, and you will forgive each other. Because when your love is enough, your love keeps you together. Your love is all you need to ignore the noise. And your love never fails. Sometimes your dad would want to throw in the towel on our marriage.
We all wish he did. We all wish he did. We all wish he would stop protecting you. That your financial crimes would be exposed to the world, putting you in prison and having him sole custodian of the boys. But he did not think you would go this far. He was desperately trying to protect the nuclear family. Mother, father, children. You, Kouri, ruined that. You ruined your boys for profit.
I would want to throw in the towel on our marriage, but we never did. We always found our way back to each other. I would pick up his towel, or he would pick up mine. We'd hand them back to each other and start again. Because our love never failed. We stopped keeping track of each other's wrongdoings, and we forgave, and we moved on, and we loved. And if I had to relive all of those hard days all over again, I would do it without question. Your dad and I were a lot of things, a mess of sorts sometimes. But we were this crazy, beautiful mess that made us a family, because our love was enough. Our hard days never outweighed our good days. Our weak moments never outweighed our most memorable happy days. We always laughed more than we cried. We failed at some things, but we never failed at loving you boys. Our love was enough to make our house a home. Our love was enough to stay together, to raise you boys.
You didn't love him. You saw him at best as a vehicle for your own happiness. A vehicle to extract money to seem successful. He was just a vehicle for you. Just as your boys also were a vehicle for you to be happy, but not for them, for you and you alone. Selfishly, you got married for bad reasons. Selfishly, you got pregnant for not because you loved him or you wanted children as a nuclear family, for your own selfish reasons. And then when that didn't work, you got to cheating and stealing. At the end of it, murder. Because you only think of yourself. Cluster B personality at its extreme. Jodi Arias, Sarah Boone, Amber Heard, Laura fucking Owens, ruining people over and over again. It's the same type of personalities here.
Our love was enough to forgive each other when others said that we shouldn't. To do things for each other others may disagree with. Our love was enough to protect each other, even though it may cost us everything. Love can make you lose yourself. Sometimes it makes you do things you know you shouldn't, but no.
You didn't love him, you never did. My theory is she trapped him. They had a quick relationship. What was it, in college? Or high, whatever. And she saw him, hey, successful family, prominent family, and she got pregnant, and then they got married. He was only a vehicle. There was no love involved here. Maybe he learned to love you. I don't know. You stole. You cheated. You stole from your family. As Autumn Dawn says, stole from their friends and family, lied to her husband about it, and was sleeping with another man who you had convinced you were leaving Eric for. Yeah, she did not love anybody but herself.
Knowing it's not wrong at the same time. Because your spouse is your person, your love is enough. One day, you will meet someone and fall in love and understand that just your love is enough. Enough to withstand everything else, the noise of the world, the obstacles, the trials of marriage, the heartache, bad choices, forgiveness.
In a good marriage, or even in a bad marriage, people don't kill, the spouse doesn't kill the other. There are extreme cases of spousal abuse, which ends up in the abused one killing the abuser. This is not one of these cases. This is a selfish, bad person who only thinks about themselves and their immediate gratification. Stealing and murder and cheating. Hopefully, your boys will have you as a warning example as to recognize if they find a girlfriend or boyfriend, I don't care, that starts to show the signs of being remotely like you, that they end it immediately and find a good person to start a family with, not an evil, conniving, murderous bitch like Kouri Richins.
You will understand your love is enough, and your love never fails. Don't worry about what others think about your relationship. Don't worry if they would do things differently. You just love. And you love big, and you love deep, and you protect your love. Your dad and I didn't have it all together. Together, we really did have it all. Because we had you three. Don't let anyone choose the direction of your life by their opinions and their judgments. Being able to hold yourself together in the worst of situations doesn't make you emotionless. Separating personal and business life and emotions doesn't make you unreasonable. Resentment can get the best of others. Don't let it get the best of you. People will always have a lot to say about lives they've never lived. Live your life the way you choose to live it. Just be safe and be healthy and be happy. That's all that matters.
Then you should stay the fuck away from them. If you cared one bit about their happiness, which you don't, you would stop trying to contact them. But you can't. You will violate every order of no contact. Because you, Kouri, only think of yourself and using people to get something from them. That's all you know.
Sometimes people will want you to believe that life is simply black and white. That situations are black and white, but they're not. Life, situations, they're full of color. At the very least, shades of gray. Always question the color, even if you're only questioning the gray areas. Keep an open mind. Question situations and stay curious. You will have some people in your life tell you how their love for you is unconditional. But once your most private life has been revealed, you quickly find out just how conditional their love actually was. Choose the people you hold close to your heart wisely. And always be the friend that walks into somebody's life when everyone else chooses to walk out. Always remember, the only people you owe your loyalty to are those people who never made you question theirs.
That's actually a very good advice. I don't think it was on purpose. Because Your motives are always questionable, Kouri. So thank you for telling them to stay away from you. For the rest of their lives, stay away from you.
Every day you wake up, you get a second chance at life. To do whatever you want. Be whoever you want. To succeed in all your dreams. Take the day and run with it. It's a blessing. Don't take it for granted. Sometimes you'll have hard days when all you want to do is count all the ways things are going wrong or have gone wrong in your life. In that moment, stop, take a minute, take a step back, take a breath, and switch your thinking to count all the ways that it has gone right. All the good that has come to you, boys. All the grace, the blessings, and the love. Remember that anyone can give up on something. That's the easy way out.
This is not them giving up on you. This is them protecting themselves from you. Because everybody needs to be protected from you. The fact that you have admirers who writes to court in order for I believe one of the letters said everybody who watched the trials, no, it was yada yada yada. You were innocent. No, anybody who watched that trial knows that you did this. Now, my personally, I was just over the bar for beyond reasonable doubt. And I do believe it was what we now know, or I now know, is that the prosecution, Mr. Bloodworth, chose to protect the boys. Many wouldn't. Many prosecutors would have had no qualms whatsoever of putting both boys on the stand, ruining her supposed alibi. Bloodworth waited to protect the boys as far as he could. And my hat's off to you again, Mr. Bloodworth, for doing that.
True strength comes when everyone is expecting you to fall apart, but you hold it together, persevering through the hardest of times. Always persevere. Always prove them wrong. Because you boys don't give up, and you boys will never quit. There's always going to be someone out there ready to tear you down, misrepresent you, lie about you, tell half-truths, and judge you. They will judge you on decisions you do or don't make, what you did or didn't do, what you did or didn't say. They will take out of context and twist your words. They will judge you on your emotions or the way you grieve. You may show too much emotion, you may not show enough. They will tell you you're not grieving correctly, you're too angry, you're too sad, you're holding it together too well or not well enough, or maybe you're too ambitious. They will judge you on your demeanor, if you cry, if you don't cry, if you don't do anything at all. And all of this will get misinterpreted into something that it's not, formed by the opinions of who's ever creating it. And then silence is also too often misinterpreted and misjudged. But when people behave that way, it has much more to do with them personally than it does you. Everyone's entitled to their opinion. It doesn't make it true.
You're entitled to your opinion. You're not entitled to your own facts, Kouri. And facts are you're a cheating, thieving, murderous woman. That's the fact. And everybody should stay away from you. And I can't believe her attorneys actually went on the record in her sentencing claiming her innocence. That is borderline unethical in a sentencing hearing. borderline unethical.
Remember who you are and what you stand for, the truth, and ignore the noise. Ignore their noise. Ignore their egos, their entitlement, and their biased judgment. Those who abuse the power and the positions they hold will have a higher power to report to one day, and that higher power holds the final truth, their final truth. Don't ever let someone tell you how to show emotion, how you're supposed to react to any given situation. Don't care what others think about you, what others say about you. Just let them talk. Just be you, be yourself, be authentic, be genuine.
That's what they are trying to be against you. Telling you to stay the fuck away. And you don't listen. You Kouri Richins, because she is unable to. She is God in her own mind, where everybody is there to provide. And if they don't do it voluntarily, you steal, you cheat, and you murder.
Because those who truly know you, who truly love you, is all you need. Forgive those who turn their back on you, but never forget. Don't hold hate in your heart toward others. It only brings you down more than it does them. Apologize when you're wrong, even if that apology is long overdue. You can't change what you can't change, and you can't change the past. But you can take accountability when you mess up. Admit when you make a mistake, even when it's...
Well, did you, Kouri? No. You're still gaslighting.
It's embarrassing or humiliating, even when it can ruin relationships, careers, or your integrity. Be honest with yourself and those you need to. But never apologize for something you didn't do. Never admit to something you didn't do. And never beg for mercy for something you didn't do. Don't take the easy way out. Always stand up for what's right, even if you find yourself standing alone or with a small group of people that love you.
Now, she has a right to be heard in her own sentencing hearing. But she's not addressing the court. She's addressing her boys, which is not a part of this case. Technically, the judge could interrupt, but he won't. Out of caution, I would imagine, that making sure there is no avenue whatsoever for a successful appeal.
Believe in yourself and be brave. Never give up on your fight, no matter how long it takes. Months, even years. Never give up on truth, justice, and the fight of corruption.
Wait. Folks, just in. Via Sleuthie, the Indiana Court of Appeals has granted Richard Allen's request for oral argument. September 21st, 10 a.m. Hopefully it will be live streamed. Oh, this will be amazing. This will be amazing. Because Richard Allen's appellate attorneys have the facts. They have the law. All the state has is harmless error. That's all they have. And maybe waiver. Maybe. But each of the arguments from the appellate attorneys in Richard Allen's case can by itself force a new trial. Altogether, it should be obligated, in my opinion. And the fact that the appeals court allows oral argument, despite the state not wanting it, is a small win in itself. This is good news, folks. This is good news. All right, let's continue. Kouri, this is not a corrupt trial or corrupt witnesses. This was a fair trial, and you were convicted. And now knowing what the boys would have testified to, that you actively hindered people from saving Mr. Richins. You actively hindered your boys to interrupt the murder. Premeditation.
Is broken, fix it. When something doesn't make sense, question it. If money is paying for it, follow the money. Your brothers are your best friends. Your dad and I raised you boys that if you cared about nothing else in this world, you care about each other.
And I chose today to gift out my 5 last free memberships. YouTube allows me to gift 10 free memberships each month, and this was my last 5, and it went to Autumn Dawn, Precosint, Babs Keeping Tabs, Love My Grandkids, and Patty Screen. Congratulations, folks. You now have access to all my members-only content. You will have early access to short-form videos, and you will have your own emojis on YouTube's. Yay! Yay!
Your brothers will always be there for you. They will always be your brothers. You love them. You protect them. You take care of each other.
They try to, and you try to hinder it by interfering in their lives. And that, let me repeat myself. Kouri Richins will not stop bothering the boys. From prison, she will do anything. She will try to recruit other inmates to make the contact for her. She will try to recruit guards, people who write to her. She will do anything to disturb her boys because she can't stop. Her actions show it. She steals, she cheats, and she kills to get what she wants.
You support each other, you help each other, and you trust one another. You be loyal to one another, and you keep each other safe and healthy and happy. And you stay together no matter what. You have each other's backs. Be patient with one another. Don't keep track of wrongdoings. Let them go. Forgive. Move on. Show compassion, empathy toward each other.
You don't have the ability to stand by that advice, Kouri, because you don't have compassion. You don't have empathy because you're a thieving, cheating, murderous woman.
And never go a day without telling one another you love each other. Because you are never too old or too cool or too busy. to love each other. Don't ever settle for just good. Go for great. In school, in your career, in hunting, in fishing, in your relationships, in your goals. Exceed expectations. Be like your dad.
Be like your dad, but choose a better spouse. Recognize the warning signs. Get yourselves and your kids away from a person like Kouri Richins. Cluster B personality. Get away from them. At best, you will be absolutely miserable. At worst, they will kill you. There is a lot of things in between. Like Laura Owens, who, when she doesn't get what she wants, she fakes pregnancy, and when that doesn't work, she gets a restraining order, ruining your life. Or Amber Heard, faking abuse. Sarah Boone, killing. Jodi Arias, killing. Kouri Richins, killing. Stay away from them. Don't put your dick in crazy.
Be generous. Be charitable. Stay humble. Give when you have too much. Give more than you take. Help when others are in need. Serve your community. Be like your dad. Never stop learning. Through education, through people, through travel, culture, through business and friends. From your success and achievements, from your mistakes and failures. Be like your dad. Love the outdoors. Find your peace, your therapy, your heart and soul on the top of a mountain somewhere where it's quiet, where it's calm, where you will be able to feel the spirits of those that you love and miss the most. Be like your dad. Laugh. Laugh often. Laugh loud. Laugh when you want to cry. Laugh when you're mad. Have that laugh that everyone recognizes and no one will ever forget. Even when you're gone. Be like your dad. Love your family. Through the good, the bad, the disagreements, the back and forth arguments. Choose forgiveness. Choose love. Choose happiness. Be a loyal brother. Be a noble son. Be like your dad. Have the hobby hobbies that bring you excitement and joy, that give you a break from life. But build your life full of people and family who you love and that love you. Build a family that makes you happy to come home to every day, with a career that makes you hold your head high.
This is a sentencing hearing, and she is using it to get to her boys instead of addressing why she should have, why she shouldn't be in prison with life without parole. She is using a majority of it to pester her children, who directly expressed anything to do with you. You killed our dad.
Be the friend everyone wants to be friends with. The dad that everyone wishes they had. Be like your dad. As your parents, your dad and I wanted to give you every opportunity or choice that we didn't have. We would do anything for you boys, or break our backs falling over obstacles and finding our way to be sure you had the best of the best.
Oh, really? Is that why you stole, cheated, and murdered? Is that how you take care of the boys? Now, even if, remove the murder, you stole from your husband, and meaning you stole from your kids. They were just pawns to you. You never thought of their best. You only thought of yourself. Only yourself.
Even if we didn't always do it well, or have the right answers, or the words, we would give you everything that we had. But the one thing I can't give you boys are the answers that you want the most.
What you can't give is their dad back because you killed him. For your own gain. Yeah. Ash Friend Psycho says over a drum ball, no tears, only snifflings. Yeah, look at that. Completely dry eyes. Because she, like Amber Heard, can't fake tears.
Because I can't give you something that I don't have. An explanation that I just don't know.
You're not prepared to give an explanation because somehow you think you can fool still can fool everyone. You can't. The evidence was there all along. The most shocking thing is you did your fucking book, your fucking letter. If you haven't been that stupid, so thank you for that, Kouri, to try to make money out of it and then try to influence witnesses once you were caught. You might have gotten away with it. You seriously might have gotten away with murder. Now, you still would have eventually been caught because you couldn't stop stealing. So your own actions made sure your boys got away from you sooner. And so thank you, Kouri, for being a fucking retard.
I've never lost a son. I've never lost one of my brothers, a nephew, or a best friend.
Oh, really? You never lost a best friend? I thought your husband was that. Right? Never lost a best friend? Self-snitching.
But I did grow up with a single mother, and I have lost my father. I do know what it's like to wonder, what if Dad could have watched me graduate college?
And you took that away from them, you bitch.
Walk me down the aisle. Be there for the birth of one of you boys. If only Dad were here. I do know what that's like. The lifetime of pain that brings. The sadness and the anger. I would never wish that upon anyone. Especially you boys. Diamond sweet babies. It's a lifetime of what ifs and if onlys. An empty hole in your heart where your dad's supposed to be.
Which you took away from them.
He's supposed to fill. He's supposed to walk through life with you, with us, with our family.
And you took that away from them.
I do know what that's like.
No, you don't. If you actually knew or cared, you wouldn't have killed him.
So murder, an attempted murder.
Now here, the so-called attempted murder. In my opinion, the evidence was not there. And the state did not present. It was... You could inference it by the later act. But by itself, I'm surprised it survived a motion to direct a verdict. I'm genuinely surprised by that. Because even if we can believe it, there were literally no evidence of it.
4 years later. And it's still hard for me to say those words out loud. They get caught in my throat. I turn my stomach. And I try to avoid them as much as possible.
So you don't accidentally tell on yourself, which you have done so many times already.
Because it makes me physically sick to think about. But still to this day, I can't believe this is real sometimes. That this is our life.
You can't believe you got caught. And you played a big part of it by self-snitching.
That this is my life. Convicted of taking one of the people out of my life who filled it the most. My husband. The father of my children. Still in shock. And
No,
still
you're
in
not.
disbelief.
That you got caught?
Accused and now convicted of such a heinous crime.
Rightfully so.
Potentially costing me to never see you boys again.
Aww. Thank God you will never be able to see them again.
I just lost both of their parents.
By your hands.
And there's no textbook answer.
Really? Didn't you write a book about losing a parent? Selling it? Didn't you? Didn't you try to make money out of killing your husband?
On how or what we're supposed to do. How I'm supposed to react or move forward. And I'm so sorry you boys are being pulled through the middle of this. It's absolute chaos. Between two families fighting that both love you so very much. Trust and assets, our home, none of it matters.
And still, you fought over it, exposing yourself to the collection of more evidence through the absolutely amazing private investigator the Richins family hired, who, if permitted, would have told so much more about you. So much more than he was permitted to say in court. More will be said about you by him in your financial crime trial, where you will be royally fucked once again, in my opinion.
You boys are what matter. Your safety, your health, mentally, emotionally, all of that should be being prioritized. I will and have always prioritized your safety. I am your mother, and that is my job. And for anyone to scare you otherwise is just cruel and heartless.
You killed their dad.
I'm sorry that 8 people from a jury who have never met you or me or our family have the right to determine our future.
Well, you could have avoided it by not murdering your husband.
And they did that in less than 3 hours.
Yeah.
In a perfect world, there might be justice. But in a perfect world, nothing ever goes wrong.
In a perfect world, you would not have killed their dad.
Tragedies don't happen. Some think a verdict or this sentencing will be the answer that they seek or that they need, but it won't. It will only give them something else to think about for a while. It may help to disperse some of their hurt or their resentment, but it won't relieve it. This grief will outlive us all. The hundreds of lives that this has affected. The lifelong trauma you boys have suffered this last 4 years will outlive us all.
What? Why would it outlive? No, the trauma you put on them will probably outlive you. They will have it for the rest of their lives. Hopefully with the right amount of counseling and help, they can avoid inflicting that trauma on their families when that time comes. That's just stupid.
You haven't had to just endure losing one parent, but losing 2.
By your hands and your hands alone.
And no child should ever have to go through that.
I agree.
Especially when one was an unforeseen tragedy.
No, it wasn't an unforeseen tragedy because you murdered him. Intentionally. Pre-planned. And you went through with it. Now, folks, in the YouTube chat, you have a link to my Buy Me a Coffee, where if you don't want YouTube to take 30% of whatever you want to give to me, now Buy Me a Coffee, I believe, only takes somewhere between 3 and 5%. So more gets to me. And you over at Rumble. Rumble takes a much smaller cut as well. Now, I don't mind super chats and gifted memberships, because it's still, I mean, YouTube still provides me with a platform. But that's what ads are for as well. So if you're here now, you won't get ads in the live stream. If you're here on as replay, you might get one every 20 minutes or so. Because I generally, it breaks the flow of the stream to put ads in it. So I'm not a fan of it. So I avoid it. If I want to force you to do supers and stuff, I'll just play some Nancy Grace for you.
And the other based on injustice and a system we're supposed to trust. Your dad's memory will always be the kind that's a physical hurt. The tightening in your chest when you think of him, particularly on days like today, his birthday. Because he was so loved.
Not by you.
No verdict or sentence will ever be able to release that kind of suffering.
No, it won't. But it will provide a safety net for the boys. And to anyone else within your reach.
I'm broken. I'm broken without your dad. I'm broken without you boys.
You don't give a shit about...
to take a life.
No, I actually agree. He did not put you on this world to take a life. You did anyway, because you're an evil, thieving, cheating, murderous person. By your own choice.
God put me in this world to give life. Your lives. And I don't know who or what I'm supposed to be if it's not a mother.
You're still a mother. Just not with, they are without, you're not within your reach. Because you're an evil, thieving, cheating, murderous bitch.
Your mother. And as much as you've been influenced into thinking that Dad was murdered, that I took your dad from you, that is completely wrong and an absolute lie. And the thought of that is still as absurd today as it was 4 years ago.
Except that you told on yourself so many times.
And just because someone may not be perfect, that's a far reach for them to be capable of murder. To kill someone. Our someone. Your dad was in physical pain. A lot of physical pain. And just because some people didn't know or didn't want to see certain things doesn't mean they weren't happening or they weren't true.
Really? So, why wasn't any of the things you put in him found in the house? If he was in that much pain that he actively had to put stuff in his body, then the house should have had that stuff. Right? Your defense attorneys said it. There was nothing in the house of this sort. Yeah, that points to pre-planning. Because it wasn't in the house. They tested him, and the only time he got that in him was that night where you locked out the boys from the bedroom, where you screamed at one son to stop bothering, where you played loud TV so you could murder without interference.
He would have never left us intentionally.
You didn't. You killed
And I
him.
would have never taken him from you.
You did.
From us. He was the glue that held us all together. That made us, us. Every little boy needs their father. Because he's supposed to teach you the things that I could never explain. He's supposed to teach you and do things with you that only a dad can do.
And you took it away from them.
And only he could give you those life lessons between a father and a son. I would have never taken that from you boys.
You lying
I
sack of
know
shit.
how much you need him. How much you love him. How much you aspire to be just like him.
Still no tears, only sniffles.
And I would have never taken that from you.
But you did.
And I'm so sorry that I can't bring him back. For you, for me, for our family.
Please be done. Oh, there's a few minutes left of this garbage human being talking.
I can beat myself up all day about how I could have been a better person or made better personal choices. And I can understand and accept you boys being upset about those things. But murder? No, absolutely not. I will not accept that. And I will not be blamed for something I did not do. I will appeal and fight these charges no matter how long it takes. Not because I have anything to prove to this court, to the state, to the Richins family, or to the world. But I do have something to prove to you three. I do care what you boys think, and I need you boys to know the truth. And because of that, I will never quit or give up on this fight for justice, the truth, and coming home to you. So please, I know that right now you may not believe me, that you believe I took Dad from you, and that's okay. I still and will always love you, and I'm asking that you please just don't give up on me. I'm coming home. Not today, not this year, but we're going to make this right. Our justice system will get this right, although this courtroom can't seem to. We have a long road ahead, but I will never quit fighting my way home to you boys. I love you.
That is witness intimidation, in my opinion. She's threatening the boys. I will get to you too.
More than these words could ever express. I loved you before I ever met you. And I will love you long after I'm not here to say it. And every minute of every day, I miss you boys more and more. And I think about how much I wish I could be with you. That this nightmare would go away. and we could have our family back. This entire situation isn't fair to anyone, but it's especially not fair to you three. And you boys are all that matters. I want to remind you just how strong you are. That you are loved by so many. And I am beyond proud of you. Of everything you have overcome, everything you have achieved, and how much you bring into this world. Sorry. You boys have been through so much. And I wish I could take away all your sadness and all your pain. Tell you how much Dad and I love you, and that everything's going to be okay. I wish I could count the freckles in your little cheeks. Read you books before bed. And help you with all your homework. Wish I could help you through your toughest nights. And hear your laugh through your happiest days. But for now, that's just not the way it is. We have to be strong. We have to remember that our strength grows in these moments when we don't think we can go on. But we keep going on anyway, because we have to push through these hard days. Because in the end, at the end of this war, it will be so worth it. But I need you boys to always keep pushing through these hard days. Because this will come to an end. I just need you to hang in there. Listen to your little hearts. Listen to your little bellies for the truth. Before you were told who to be and what to believe, remember who you are. Remember who we are. Remember our family. I will continue to call you every day, even if my calls are blocked. Just so you know that I'm here. I've always been here. And I will always be here. My cards, my letters, they will never stop. I will never stop. I love you forever, Mom.
Thank God that is done. What an absolute pile of horse shit. Absolute pile. By a thieving, cheating, murderous bitch. Still, trying to affect people around her. Still claiming somehow he accidentally overdosed. Folks, the amount that was found in him was enough to kill a dozen people. At least. It wasn't an accident. It was Kouri, who made sure he would die and that nobody could interrupt her killing, including locking the bedroom door, screaming at the kids, turning up the telly so nobody could hear his struggle. The premeditation in this is above and beyond.
That's all I got. I'll take it for you.
Okay.
All right,
Yep.
ladies and gentlemen, a fair reminder. While inside the courtroom, everyone involved in this process must be treated with respect.
Now, this, he's going on a bit of a speech, so I'm actually going up to 1.25 speed now.
We cannot have any outward reactions inside the courtroom. If any of you feel overcome with emotion, frustration, anger, whatever, of any kind, please remember just to look down. Keep your hands folded in your lap. The court has considered the following information: the evidence, information, arguments, and recommendations provided by counsel on the record today, victim impact statements and other statements made on the record today regarding the appropriate sentence, and the pre-sentence investigation report as corrected on the record today, including the numerous statements attached to it. In addition, the court has considered each of the factors set forth in Utah Code 76-3-201 subsection 2B and has prioritized those factors as required by section 201-2C. Having considered the gravity and circumstances of the offenses for which Ms. Richins has been convicted, the number of victims, and available information regarding the history, character, and rehabilitative needs of the defendant, the court hereby orders that the sentences on counts 2 through 5 shall run consecutively to each other and to the sentence imposed on count 1. Moreover, the court exercises its discretion and chooses to impose no fines related to any sentence in this case. The court addresses the 5 counts on which Ms. Richins was convicted in reverse order. Ms. Richins, based on your conviction on count 5, third-degree felony forgery, the court hereby sentences you to an indeterminate prison term not to exceed 5 years. Based on your conviction on count 4, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 3, second-degree felony insurance fraud, the court hereby sentences you to an indeterminate prison term of not less than 1 and not more than 15 years. Based on your conviction on count 2, first-degree felony attempted aggravated murder, the court hereby sentences you to an indeterminate prison term of not less than 5 years, and that may be for life. Which brings us to the final issue, the appropriate sentence for count 1. Under Utah Code 76-3-207.7, there are only 2 options: an indeterminate prison term of not less than 25 years, and that may be for life, or life in prison without parole. And the law requires that the court consider each option. Under a sentence of 25 to life, and considering the effect of the 4 consecutive sentences, the time that Ms. Richins has spent in custody, and the current practices of the Board of Pardons and Parole, Ms. Richins would likely serve approximately 30 years in the Utah State Prison before receiving her first parole hearing. By that time, she would be 66 years old. Under a sentence of life in prison without parole, Ms. Richins would be in prison for the rest of her natural life, unless the Board of Pardons and Parole determines by clear and convincing evidence at some future point that she is permanently incapable of being a threat to the safety of society, at which time the board would have the authority to release her. Under either scenario.
Yeah, that is deadly illness, final stage cancer, severe dementia. That kind of thing is what, yeah, she is life without parole, but she will be in a nursing home without a more or less low brain function. That is the exemption.
Ms. Richins will be incapacitated, meaning structurally prevented from harming anyone outside the Utah State prison system for at least the next 3 decades, and perhaps much longer. But the potential impact on the survivors of the tragedy created by Kouri Richins, most importantly, Eric Richins' 3 sons, is more difficult to predict. On one hand, if the court sentences Ms. Richins to life without parole, one or more of those young men may come to resent that the court eliminated any opportunity they might have in the future, decades into the future, to express an opinion as adults with substantial life experience about whether their mother should, for example, be allowed to die with dignity. On the other hand, if the court sentences Ms. Richins to 25 to life, one or more of those young men may spend the next 30 years questioning why the court failed to protect them from the prospect of the person who murdered their father being released from prison at some time in the distant future, perhaps when they have families and children of their own. The court's contemplation of how those young men may come to feel about today's decision some 30 years from now comes from a place of genuine concern for them and humility regarding the court's inability to predict the future. Sitting here today, it is simply not possible for anyone, not even those young men, to know how their view of this case may evolve over the next several decades. My hope is that every person affected by Eric Richins' death will, over time, find their way to a state of peace. As for today, the court's duty is to make a decision, a weighty, long-lasting decision based on the best information available today. And the bottom line is this. Kouri Richins was convicted unanimously and beyond a reasonable doubt of attempting to murder Eric Richins, her husband, and the father of their 3 children. And then, having failed in her first effort of spending the next 17 days, not changing course, but doubling down, preparing to try again, and ultimately completing the act through the administration of poison. And for what? Money. All for pecuniary gain. A person convicted of committing that sequence of acts in that way and for that reason, and who causes the absolute tragedy that has befallen Eric Richins' sons and family. A person convicted of those things is simply too dangerous to ever be free. Accordingly, Ms. Richins, based on your conviction on count 1, first-degree felony aggravated murder, the court hereby sentences you to life without parole. You have the right to an appeal. You must file a notice of appeal within 30 days. You have the right to be represented by counsel on appeal. Mr. Bloodworth, anything further?
No, Your Honor.
Ms. Lewis, Ms. Nestor.
Your Honor, we anticipate filing a motion for a new trial and would like a date set. We have a substantial record in this case. We will file a notice of appeal of the conviction and the sentence and ask that everything be stayed pending the motion for a new trial as we're entitled to do under Rule 4B. Excuse me, but we think we need sufficient time to file a motion for a new trial based on the substantial record that exists in this case, longer than the typical 14 days, because this is not only the trial itself, but the years of litigation and motion practice that preceded the trial. We were hoping that we could get an agreed deadline of 90 days to file a motion for a new trial, mainly because for half of June I'm out of the country, for half of July Ms. Lewis is out of the country. Normally we would ask for 60, but there's going to be a month in there where both of us aren't available. So we're asking for 90 days.
All right, Mr. Bloodworth.
Your Honor, the state objects. The rule provides for 14 days. You can't imagine this is a decision that was made today. I think council's had the last 53 days to prepare the motion, 14 days pursuant to the rule. I appreciate that it's a lengthy record in this case, but the issues available for the trial are fairly narrow. The state recommends a 14-day time period as provided by.
Yeah, and I would say, addition to that, if they handed over the case to appellate attorneys, I would see 90 days. But they have all the information because they've been there for years. So 14 or maybe 30 days. Yeah. 90? Nah. It's not the court's problem that you will be out on vacation. If that would affect the appeal, then hand it over to appeals attorneys. And also, for any type of successful appeal, these guys, her attorneys, should not be in the picture. Should not be in the picture. Their clear bias is clouding their judgment, in my opinion.
There is one other thing, Your Honor, on that as to why we need the extra time. So we have asked the county to retain an expert to assist to do a declaration for attached to our motion for new trial, and it's going to require us to go before a separate entity to decide whether that funding is approved, and that just takes time. So that's another issue we need.
I feel like there's more that I need to know in order to make this decision. And so I can also appreciate why a defendant is concerned about the 14-day deadline so they do not lose that opportunity. Sitting here today with very little information and the state having very little opportunity to respond to this idea, I'll extend your deadline to 28 days. But within that time, if you want to file a motion to extend it, Ms. Nestor, with more detail, you have 14 days to file that motion.
That's reasonable.
Clarification. So the court.
14 days from now, they have an opportunity. They have a deadline to file a motion to extend the 28-day deadline. If they don't, it's 28 days.
Gotcha.
Yeah, reasonable.
I acknowledge that that 28-day deadline may cause practical difficulties for the state's team, and if I need to extend the state's response deadline, I will certainly give that fair consideration.
Understood.
Ms. Nestor, Ms. Lewis, anything else today?
Yes.
Ms. Richins, you are hereby committed to the Utah State Prison and remanded to the custody of the Department of Corrections. This court is in recess. Please follow the deputy's instructions. We're off the record.
Let's see if there is anything else. Now the rest is commentary by Court TV. So folks, Kouri Richins' life without parole and consecutively. She will never be out of prison. Now she has the right to appeal. I seriously doubt that any appeal will be successful on any part of this. And on top of that, she will soon have a trial regarding her financial frauds. A lot of counts that was never disclosed in this trial, which will render her decades, if convicted, in prison as well. She will never see the outside of a prison wall unless she's carried out or incapacitated to the extent she cannot be a threat to anyone anymore. That's great news. Now, folks, I'm going to send you over to Megan Fox because they are talking about Laura Owens. And they're holding a fundraiser for the Mike Maricini, because Laura won't stop abusing him through the legal system or otherwise. His current legal bill is over $100,000. We have fundraised a bit over $50,000. So I'm going to send you over there. Thank you for staying with me for this 3 hour stream. Thank you so much for being here. Now on my channel, I'm going to wait until tomorrow so I can have Mo here for the last day of the Senator Mitchell trial. And we know that Senator Mitchell herself will take the stand with sob story, victim blaming, gaslighting. It will be a lot of snark tomorrow. And also tomorrow is Friday. It is Slightly Buzzed Friday show. So we will what are we going to talk about? Well, Laura Owens is a clear subject. We will see. We will see tomorrow. Again, thank you for joining me. You all have a good one. And I will see you in the next stream or video. Bye-bye.